Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been following the Appellate case, styled as Richard M. Allen versus State of Indiana. This is an active appeal. Mr. Allen was convicted of the unalivings of two young friends, Abby and Libby, in a small town back in 2017, is when those tragedies occurred. Mr. Allen filed an appeal in the Indiana Appellate Court. He is alleging, amongst other matters, that the sentence should be set aside and he should be granted a new trial based on various allegations of violations of his Fourth Amendment privileges to be free from illegal searches and seizures. Mr. Allen's appellant brief, it was filed December 18th, 2025. Now, the state had an opportunity to be heard, and after a couple of extensions of time granted by the court, the state of Indiana responded with the Appellate brief on the 25th of March, 2026. They are very vigorously opposing these convictions to be overturned. They have denied any reversible error here, and they want the sentence to stand. Mr. Allen is entitled under the Indiana Appellate rules to be heard one last time in the filing of a reply brief. What is a reply brief? A reply brief does not give him a second bite of the apple and rehash his initial brief on the merits from last December. No, it's supposed to be strictly limited to any content he wants to rebut that is contained in the Appellee's brief of the 25th of March. Now, usually under the rules, he had 15 days to get that reply brief in, but what he did is on the 31st of March, he filed a motion for extension of time to file his reply brief. He also filed a second motion to file an oversized, that means a larger brief than would be, has granted one of these motions. On April 1st, 2026, today, the appellate court filed an order granting the motion for extension of time to file this reply brief. And it reads, having reviewed the matter, the court finds and orders as follows. Number one, appellant's verified motion for extension of time for filing appellant's reply brief is granted as a final extension, and the appellant's reply brief is now due on April 23rd, 2026. We have a copy of the court order granting Mr. Allen this relief on our community page of our sister YouTube channel. There's a link in the description to this podcast episode if you would like to read it. But basically, the court is saying here, this is a final extension. So making it sound like this is it. That reply brief's got to get in. We got to get things moving here. And this is signed by the Chief Judge of the Court of Appeals in Indiana. So we will be looking for that reply brief to be filed on or before the deadline, April 23rd, 2026. And after that happens, one or both of the parties could request oral argument. That's a hearing where they would have an opportunity one last time to assert their positions at a hearing before the appellate court. It's not a requirement. There are no such motions as of right now. And if neither side moves for oral argument, then the next thing that would happen is that the appellate court would rule either in favor of Mr. Allen or against Mr. Allen in favor of the state of Indiana. So matters which have been pending for quite a while in this appellate court are now getting closer and closer to this ruling in Allen versus Indiana. Please stay tuned to the Indie Zone for further updates. Until next time, this is Kathy. Thank you for joining us here today.